Welcome back. This is the module on the non-statutory labor exemption. It'll be class 5. It's hard to understand the non-statutory labor exemption without talking about Major League Baseball and how it intersects with the antitrust immunity. So one of the updates that we have for you here, and we've talked about it before, and the PowerPoint that is now scrolling through talks about how we can use the MLB and MLBPA 2020 negotiations to illustrate the concept of the non-statutory labor exemption. So Ryan, I've asked you to be our baseball expert again. We've got these bullet points here. Now remember, we've learned about the baseball antitrust immunity in chapter 3. We've learned that the business of baseball, according to the Supreme Court's denial of cert in San Jose and Miranda and all sorts of other cases, that arguably they're exempt from antitrust immunity. But why when they're at the bargaining table, must they be careful and maybe even get a grievance and or an unfair labor practice charge, or perhaps even an antitrust suit? Let's go through it in some seriatim fashion. MLB in the 2020 season, we know that it's coming to an end. We're going into the expanded playoffs, which really monetizes the media rights. And then the heart of the negotiations, there's our two issues. We've kind of been over these before. And after many rounds, right, the league implemented, right, best and final offer implementation. Think about the Tony Brown Supreme Court case, which we're going to look at as sort of the seminal, bargaining in good faith impasse. Can a league implement its best and final offer? And MLBPA reserved its right to file a grievance. Ryan, we've stated the case. If this were to happen in the NFL, would Tony Brown control? I mean, best final offer, all at the negotiating table had been negotiated. So let's just call it that was their best and final offer. It all been negotiated in good faith. Begin with the end in mind. That's the ultimate Supreme Court case. Tony Brown says if at the table, not too far away, from the table, implementation was made. All those things, boxes seem to be checked here. What do you think? Are we down to a labor grievance, or could there be, what other recourse could there be? Breyer versus Stevens, the majority versus the dissent. In some of these cases, we're going to be looking at this, but the Tony Brown case ultimately is going to be our lodestone, our lodestar case. How do you think, just thinking out loud, it's likely to come out?
Yeah, I would think that the MLB has a strong footing here after the multiple rounds of negotiation that the MLBPA had. So you alluded to it with the best and final offer. So based on that fact that, they had that agreement, if they had ended at the agreement to agree, and then the commissioner unilaterally implemented the season without further discussion, the PA would probably have a much stronger case because they never actually negotiated the number of games or anything of that nature. And so the non-statutory labor exemption trying to give effect to collective bargaining wouldn't really apply there because it was never bargained for or attempted to be. But because we had a very public multiple back and forths between the MLB and MLBPA, where they got to, I think MLB was at like 55 or 50 games, and then the MLBPA was at 70 or 65, and MLB offered 60. That does seem like their best final offer. The only thing, not the only thing, but a strong thing the MLBPA might be able to hang its hat on is that the commissioner agreed to a duty to play as many games as possible. That was something he contractually bargained for, and they could potentially have a grievance over that either they didn't negotiate in good faith, or they could have had a longer schedule that could have allowed for more games and thus higher salaries for the players.
And we're reading from page 136 of the book and following. And could they have, as we go into the next collective agreement, let's talk about a little bit earlier, 134, Freeman McNeil's decertification and run. Now we're past this. Let's say they can file a grievance, but no antitrust because it happened at the table, and therefore it's protected by the non-statutory labor exemption. What about the decertification strategy that was employed successfully by Freeman McNeil? Now we're at page 134 of the book. And then, Tom Brady, the Brady versus NFL, 139, the decertification and run failed. Again, using Tony Brown as the main reason for why it failed. Now I'm reading over to page 140 in the book, and we don't want to get too far ahead of ourselves, but as the class reads forward into this non-statutory labor exemption and then reads back into what happened to in the MLB and the MLBPA, could decertification now, as they go to their next collective agreement, result in each and every player having standing to sue? In other words, under the Flood Act, if you're on a 40-man roster, you technically have standing to sue, right? That's what the Flood Act certainly allowed a major league player to have, standing to sue. No one's ever sued. But now we've decertified, so you've lost the control over that which happens at the table is protected from antitrust scrutiny. So now everybody's a free agent because you had an effective decertification. Is that the parade of horribles MLB should be concerned about, a decertification strategy?
Well, I don't think we're at a decertification strategy just yet because they still have some time before their collective bargaining agreement runs out. But it is an open question of whether or not it would work. Like you said, we've seen it work once and we've seen it thwarted another time. And what seems to be going on here could potentially be the court just evaluating, I guess, whether it's a real decertification or whether it's a way as an end around to get a lawsuit. And the current situation as it's laid out, if it progresses, it might seem like the decertification is not necessarily in good faith or a fair or just an end around, because they have this grievance currently hanging over MLB's head, as well as a litany of complaints between the two sides and a thorough amount of negotiations. A decertification could conceivably play out like we saw in the latter case on page 140 and following, rather than originally in Freeman McNeil. But that is a bit of an open question, something MLB would certainly want to stringently avoid by getting these negotiations taken care of.
And just to teach to, this particular hypothetical, you look at really what happened in the Brady, the most recent decertification strategy, and ultimately it's a citing back to Brown in the middle of page 140 there, just to help guide the reading. We're all the way back to Norris-LaGuardia Act and talking about whether a union exists or not, whatever the precise limits of the phrase involving or growing out of a labor dispute. This Brady case, this decertification case, did not press the outer boundary. They were parties to a collective agreement for many, many years, 18 years prior to 2011. And whatever the effect of the disclaimer, whether you call it disclaimer decertification, from antitrust liability, this dispute did not suddenly disappear. It is still a labor dispute, and it should be resolved through, not through antitrust litigation, but rather through collective bargaining. So ultimately, that's the kind of constant here. When we read through this chapter, we're going to be looking at the evolution of the non-statutory labor exemption. It comes out of United Mine Workers. It comes out of Connell Construction on page 1, set up in order for the current NFL practices to survive antitrust scrutiny. Is that a fair statement of what we're talking about here, Ryan?
Yeah, so you want to remember that the non-statutory labor exemption is the court's attempt of straddling two different federal laws, antitrust laws, as well as Congress's labor law regime. And so the non-statutory labor exemption is trying to channel the parties to the bargaining table. And in the earlier cases, we definitely saw the court doing that by preventing the leagues from saying, you're just going to have your way. You can't impose that. You have to go to the table and negotiate with the players. Some of the more recent cases seem to tilt in the other direction against the players, saying you can't just run to court when you're not getting your way with the league. You need to go back to the table. And that's what seems to be going on in Brady with this whole, it's sufficiently close in time to growing out of the labor dispute. So that's an open question, but the courts are trying to channel the parties into a collective bargaining agreement because that was Congress's intent. So it's an open question and it's a fact-based question, but that it is certainly possible that they could face decertification issues along with a litany of other antitrust and competitive issues if they don't get a deal done. And the longer it drags on and they don't have a deal, the more likely it is that they'll wind up in court and be on the losing side of it, the MLB.
Yeah, and don't forget the dissent. I referred to it in Brown on page 138 as the other side of the coin. I won't read through it there. In the Eller case, in footnote 49, suggests that perhaps Mackey is no longer good law. Query whether it is or it isn't. But because in Mackey and Yazoo Smith, there had not been meaningful negotiation at the collective bargaining table, they were able to achieve their antitrust results. And the question is on the other side now. I think if you were on the league side, you would be silly not to continue to discuss things going all the way back to MLB and MLBPA until you reached impasse. engage in good faith bargaining, and then implement your best and final offer or the equivalent thereof. I mean, by going back to our hypothetical here, Ryan, by putting in extra playoff games, which means more money for everybody, at the end of the day, the grievance, if there is one, would be mitigated because there's more money coming from more playoff games that are being televised nationally and internationally. Isn't that probably what Rob Manfred would say back if there's a grievance? Where's the damages, if any, from playing fewer games? I've mitigated, or we've all mitigated
Yeah,
by playing more
exactly. Even
playoff
if the
games.
parties can, even if the players can hold the league accountable, they still have to have suffered some sort of loss or damages. And playoff games, as you alluded to before, is where the money is due to TV contracts. So the players might ultimately get more money out of this based on the additional playoff games by the shortened regular season. That would all be a fact-based question, but neither party can just mail it in, so to speak, on this. The courts really want them to give a good faith best offer at the table before having the courts resolve the problem.
We've got a whole study guide on NSLE tests and timing. This is at page 150. Zach, I'm going to call on you here pretty soon for the NBA trilogy, Wood, Williams, and Caldwell. And Aaron, I want you to chime in too. But post-expiration, post-impasse, page 151, unilaterally imposed new terms post-impasse. When does that result in an unfair labor practice charge? And I'm going to come back to Silverman as being instructive here too. That's at the bottom of page 151. The case is cited and summarized at 116 and 106. But Silverman sort of threads the needle, I think. Maybe Aaron, I'll ask you this question: how does Silverman, a baseball case, come into this chapter of the book, chapter 4 of the book? How is a baseball case, Silverman, where we have a study guide on the baseball antitrust immunity, page 116, I believe it is. How does Silverman come into play to determine what has to happen at the table and what is therefore exempt from antitrust scrutiny? Yeah, Silverman is 114 and 116 and following, Silverman versus Major League Baseball Players Relations Committee. I'll ask Aaron that one. Then Zach will finish up. I'll come back to you on Wood, Williams, and Caldwell.
Yeah, so Silverman is instructive, obviously, because you bring in MLB with the MLB antitrust exemption, and you think there, when you're actually collectively bargaining, like, if we're going to file why do we need to do this if we're going to file an antitrust lawsuit? And it was, if we reach impasse and they unilaterally implement, can we file an antitrust lawsuit? And avoid the non-statutory labor exemption as a defense. And was it Justice?
Then Judge Sotomayor, at the trial level.
I was going to say Judge Sotomayor said, if it's related to mandatory conditions of employment, it must be collectively bargained. You can't rely on the MLB antitrust exemption to get through there. So pulls it back in all through the non-statutory labor exemption, as you said, threads the needle, brings it back in to that concept. So it has to be a bargain at the table.
And if it's bargained at the table or not that long after, not too far distant in time, we'll learn from Brown. Right. Those are the 3 conditions on page 116 for even holding baseball, because once they're in a collective bargaining environment, it's the labor relations rules that control, not in the baseball immunity. Baseball antitrust immunity no longer controls once they're at the table. They must negotiate. They can't take things away arbitrarily, which in that case would have been issues of free agency and essentially taking away things without bargaining in good faith, taking away really important things that had been previously negotiated. They have to negotiate in good faith because the labor laws control that, not the antitrust laws, once they are at the table. And Zach, so then just to finish up on this update but overview of chapter 4, we talk about the NBA trilogy, and that's going to lead us to ultimately to Claret, which is going to be age eligibility. But Wood, Williams, and Caldwell, really, really quickly, this is page 145 and following. What is happening here? What is happening to the non-statutory labor exemption in the Second Circuit in these 3 cases?
In all 3 cases, it looks like the non-statutory labor exemption is being strengthened. They're saying it's holds in these cases, and they're even going further to saying even at impasse, or if they're post-expiration of the CBA, if they unilaterally impose it, it is still holding. And so it looks like the court is just strengthening the rule of the non-statutory labor exemption.
Terrific. So just real quick, let's finish up with these review questions. Ryan, come back. You know, we've got all the tools that we need to address these questions. We don't want to give you the answers. They may well be on the final. But I think what we're saying is you want to study really long and hard the book when you get to this point and talk about the contours of the NSLE in sports, page 149 and following as well. And an labor management consent approach, question mark, collective bargaining relationship approach, question mark, expired CBA terms post-expiration, post-impasse. You have to keep looking at all these temporal issues and then unilaterally impose new terms post-impasse. That's where we get to Silverman. But taking it back to this hypothetical, if this had been a CBA negotiation, not an interim negotiation because of COVID, I'll just ask you what your opinion would have been. Is their imposition of their best and final offer, even though it wasn't technically within the ambit, it didn't have the maximum number of games which it was supposed to have. What would you recommend to the Players Association that they do in that situation? Again, having mitigated the damage, arguably, by the league throwing and the PA agreeing to more playoff games.
I think the PA still has a strong case to pursue what did happen at the table and when it did happen, and you need to strongly consider that. And as you alluded to before about unfair labor practices, there's not just antitrust lawsuits that happen here. The non-statutory labor exemption and antitrust exemption are broad and powerful, but the commissioner still needs to operate within what he agreed to and what is agreed to there. So if this was a CBA negotiation and they think the commissioner is operating outside of what they agreed to, it might not be an antitrust lawsuit or an anti-competitive one, but there could still be potential violations they should look at.
Awesome answer. I'll just direct the class to, we do have additional case summaries at page 402 and following in the book. So as we go through these, you're really going to want to take a quick look at some of these updates, different case summaries for different chapters, starting at page 402 and following. Additional case summary study guide, page 402. There you have a really good further treatment of Mackey and Claret. And again, a nice statement on Claret at page 403, and that gets us into age eligibility. So we'll pick up right there because Claret is ultimately our age eligibility module, but this is our transition from non-statutory labor exemption to the application of same in the context of age eligibility. And thanks for your attention to this chapter 4 update and refreshment. And we'll see you for chapter 5 shortly. Thank you.